Hello everyone and welcome to our fourth video tutorial on the topic of civil courts and civil process. So far in video 1 we've looked at the civil court hierarchy and appeals. In video 2 we looked at how the Wolf reforms altered the civil procedure rules. In the third video we looked at how claimants actually start a civil claim using an M1 form and the 3 tracks that claims can be allocated to. And today I'd like to talk to you about civil juries and also tribunals. So we're going to start with juries today then. This is going to be very brief because we actually look at the topic of juries on its own as a whole topic in our lay people topic. In that topic later on, we look at lay magistrates and also juries. But I just think it's worthwhile, while we're looking at the civil system, to look specifically about when juries will be used in a civil trial. Have a look at the next slide then. I've outlined all the key points you need to know on civil juries. So the first thing to say is that juries have a very limited use in civil trials. They're used in criminal trials, more than in civil ones, very limited use here. And they're only used for these 3 types of trial: civil fraud, malicious prosecution, that's where you are alleging that the police are perhaps going after you for malicious purposes. Stephen Avery springs to mind there. Or false imprisonment, when you've been falsely imprisoned, potentially locked up by the police perhaps with no good cause. So it's actually a very limited number of cases. Any other civil case will not use a jury, and it amounts to less than 1% of civil trials. So you need to be aware that juries can be used in civil cases, but we can see it's very limited. And the composition of a jury will vary depending on which court it's in. So juries can sit in the High Court, in which case you would have a minimum of 9 jurors, up to 12. If they are in the county court, you would have a minimum of 7, but up to 8 jurors. And in a coroner's court, a minimum of 7 and a maximum of 11 jurors. Now, I've not mentioned the coroner's court to you before. Obviously, we've come across the High and the county before. A coroner's court is a special court in which we decide the cause of death in suspicious circumstances, such as if someone dies in prison, police custody, industrial accident. We used coroner's courts to determine the cause of death in Hillsborough as well, to give you a famous example there. So we say that juries have a dual role in a civil trial. That means they've got 2 key things that they have to do. Firstly, they have to decide whether the defendant is liable or not on the balance of probabilities. So remember, this is the standard of proof in a civil case, the balance of probabilities. That's different from in a criminal trial, which is beyond reasonable doubt. So here they're deciding, do they think the defendant is liable or not liable on the balance of probabilities, which basically means, is it more likely than not? If they think the claimant has proven their case against the defendant, they then go on to decide what damages are awarded. So damages, remember, means compensation. So liable or not liable, and if they find them liable, they decide how much compensation the defendant is going to pay as well. In terms of advantages of civil juries, you could refer back to the Magna Carta here, that recognise the fundamental right to be tried by your peers. But people have talked rather extensively about disadvantages, particularly of civil jury trials. And there's disparity or inconsistency between jury awards of damages and awards of damages by judges. And people, including Denning, have said that it would actually be better for the judiciary to be responsible for valuing claims rather than a jury who doesn't have that wealth of experience. So I actually want to leave it with for juries there today, because as I say, we're going to come back to juries when we look at our topic of lay people. So for now, we're going to go on to look at the next part of our civil system, looking at tribunals. So if you remember from a previous video, we saw that tribunals are not part of our court system per se, they run alongside it. And when we were looking at the civil court hierarchy, we saw that it is possible for a tribunal to join the court system. And I think I'll just switch back to that slide to remind you what I mean here. So if you remember this slide from a previous video tutorial, we've got our civil court hierarchy here from county up to the supreme, and we can see that tribunals are running alongside. So they're not strictly part of our court system, but they run alongside it. And what I mean by it is possible for a tribunal to join the court system is this arrow that you can see here. What we're going to see a bit later in this video is that once you've exhausted the tribunal appeals, if you are still not happy, it is possible to appeal from an upper tier tribunal up to the Court of Appeal. And we're going to look at a recent case involving Uber as an example of where a tribunal did end up in the court system. Okay, so that's what I mean by them running alongside the courts. So I'm just going to switch back to where we were for you. And if you look at the next slide, which is on this Civil Courts and Process PowerPoint, there's a video clip link here. Now, this link takes you to a really useful video that just gives you a really nice introduction into tribunals and ADR. So once you've finished with this tutorial, I do advise you go away and watch this one as well, because that'll give you a little bit more information. And if there's anything you don't quite understand from what I'm saying, this particular video might help clear it up. But I'll try my best to give you a nice overview of tribunals now. So, tribunals are running alongside our court system, and they are used instead of a court, and they are used for deciding certain types of dispute that we feel that we can decide outside of the court system. And they are less formal than courts usually. And tribunals are massively important to us because you can see here that they actually handle over 1 million cases per year. So if we didn't have tribunals working alongside our courts, our civil court system would be completely swamped. And we know that the civil system already faces delays and costs, so it simply wouldn't be able to handle this 1 million extra cases. So tribunals are very important. They were created after World War II with the development of the welfare state, and they are there to allow people to enforce their social rights without having to go to court unless absolutely necessary. And you can see here they're used instead of court proceedings. It's important to point out at this point, though, that tribunals are inferior to the ordinary courts. So their decisions are important. If you go to a tribunal, you will get a judgment, an important decision. But in the case of Peach, Gray and Somers, it was confirmed that a tribunal decision is inferior to the ordinary courts. So if we did appeal up to the Court of Appeal, as I mentioned before in the Uber case, it would be the Court of Appeal decision that would stand, not the upper tier tribunal. And that's because our civil courts are superior to tribunals. And you need to be aware that there are 3 types of tribunal which deal with different types of dispute. So you can see here we've got administrative tribunals, and these are dealing with disputes between individuals and the state, and it's where there's been a dispute about the rights contained in social welfare legislation, such as social security, immigration and land. So it might be that an immigrant is challenging a decision that's been made. It might be a social security issue, or people not getting the benefits that they think that they're entitled to. That could go to an administrative tribunal. A domestic tribunal is a tribunal that's used for disputes within private bodies. So the Law Society, which regulates solicitors, the GMC, which is regulating doctors and the medical profession. So that's going to deal with those specific disputes. And in a domestic tribunal, that particular tribunal is going to be expert, experienced in dealing with, say, solicitor disputes or medical professional disputes. The third type of tribunal is the one that you've probably heard of. These are the most common type of tribunals, and they are employment tribunals. And as the name suggests, they involve disputes between employees and employers over employment legislation. So these might involve cases where, for instance, your claimant is claiming that his employer has unfairly dismissed him. There might be a claim relating to redundancy or discrimination in the workplace. Those are the sorts of things that are heard in employment tribunals. This is a good point to talk to you about a recent case, which is an example of a case that went to an employment tribunal, appealed up into the upper tier employment tribunal, and then went on to appeal to the Court of Appeal and is now actually looking to go on to the Supreme Court. And you might have seen this in the news. It was from 2018, so it's fairly recent. And it was a case involving Uber. And I've just got a clip from the BBC News here. You might remember that picture from the press. But if I go on to the next slide here, we've got our case study. So this case was called Uber and Aslam and Farah. And you can see here that in October 2016, there was an employment tribunal against Uber. And basically, Uber were classifying its drivers as independent contractors rather than employees. And this meant that Uber didn't have to give them as many rights. And so Aslam and Farah were claiming against Uber in this tribunal and saying that they were actually employees. And the tribunal agreed with them. The tribunal said, yeah, you are employees and you are entitled to minimum wage, holiday pay, and the other benefits. Uber wasn't very happy about this, so they appealed to the Employment Appeals Tribunal in 2017, but again, the Appeals Tribunal upheld the earlier decision and said they are employees, you must give them their rights. Uber then went to the Court of Appeal, and it was a split decision. You can see here the decision was 2-1 with our judges. So it shows that, it wasn't a clear-cut case perhaps. But again, the Court of Appeal agreed that the drivers were employees and they were entitled to these rights. And Uber are looking at whether they can appeal to the Supreme Court. But the reason I'm showing you this case is it's just quite a nice, fairly easy to understand case study that illustrates an example of an employment tribunal that went through the full tribunal process, and then it did actually end up in our civil courts as well. So I will mention the tiers of tribunal again shortly, so I'll refer back to this at that point. So tribunals were set up as part of the welfare state, and there were 70 different types of tribunal originally, which was really complicated. So we got the Tribunals, Courts and Enforcement Act of 2007, which created the first tier and upper tier tribunal, which I've just mentioned to you there with Uber. And you can see here on this slide that what happens is a case like Uber starts in the first tier tribunal. It can appeal up to the upper tribunal, as Uber did. And then if they're still not happy, it can go on to the Court of Appeal, again, as Uber did. So this is how our tribunals can join the civil system. I'm running out of recording time on this video now, so I'm just going to get the advantages of tribunals up on the screen here. I think they are quite self-explanatory, so I would pause it here and take notes on these advantages, and then I will do the same for the disadvantages. So here, if you pause the screen again, I've bullet pointed the disadvantages of tribunals. And there's more detail in your booklet which you can read on this as well.